When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of atrocious acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful,
no matter how minute,
no matter how minute.
Who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of the program Justifying Nigeria on ACNN television, reaching from Abuja. On today's episode, our subject of discussion will be on the legal concept of court order. My name is Anozechi Nomso, your uncle. A court order is an official proclamation by a judge, justice, or panel of judges or justices that defines the legal relationships between the parties to a hearing, trial, an appeal, or other court proceedings. For a general understanding, a court order is a formal written command issued from the court requiring the performance of a specific act. This means that once an order has been issued by the court, no court of coordinate jurisdiction has the right to reverse such order unless on appeal. But regrettably, the era of conflicting orders by courts of coordinate jurisdiction seems to have appeared again, mostly over political party power tussle, as seen in the cases of Mr. Uche Secondus, stopped from parading as the national chairman of the People's Democratic Party, PDP, and All Progressive Grand Alliance, ABGA, Anambra State governorship candidate in the November 6, 2021 polls, Charles Soludo. These conflicting orders of courts has prompted a worried Chief Justice of Nigeria to summon 6 chief judges of the state high courts that are involved in all of this, which are Rivers, Kebbi, Cross River States, Anambra States, Jigawa States, and Imo State over the development. What then is court order in its entirety? What could be the cause of these conflicting orders of courts? And there are some justifiable legal circumstances by which conflicting orders could be sustained. Is the summon of the 6 affected chief judges by the Chief Justice of Federation a right step in the right direction? With me in the studio to address all this is Barrister Eudora N. Ezonye. She's an Abuja-based legal practitioner, managing partner at Waldo & Co. Legal Practitioners, member of Chartered Mediators and Conciliators, and also an active member of Unity Bar here in Abuja. You are welcome to the program, ma.
Thank you.
Thank you so much. Oftentimes we hear and talk about court order, and you agree with me that there are some viewers out there that are not lawyers like you that will be hearing about this court order, but they don't know what it means. Now, in a short, in a short form or in a summary form, can you tell us what court order is all about?
Yes, just like the name entails, court order. These are directives given by a court or a judge on a suit pending before him, either to stop the doing of an act or for an act to be done.
So once a judge issues an order directing a particular thing to be done or not to be done, that is a court order.
Yes.
So does it mean that a judgment is also a court order? A judgment on its own is a court order?
Judgment on its own, judgment is not really a court order, so to say, because judgment is superior. When I mean superior, it's not as if court order are inferior, but judgment is after the suit on its merit. Judgment is gotten at the end of a matter, after the pros and the cons have been separated. But before judgment, an order may be made.
Okay.
They are called interlocutory injunctions. They can be made pending the judgment. In some cases, the judges may tell you, don't worry, the order will come along with the judgment.
Okay, some orders that are made before the judgment is what we are discussing. It's what court order is all about.
Yes.
Not necessarily the judgment on its own.
No.
Okay, some of you talked about interlocutory injunction.
Yes.
What is interlocutory injunction? Can you tell our viewers what that is all about?
All right. For instance, now, you are living in a house and coming back from work, you find out that there is an inscription written on it. This house is illegal structure to be demolished in 2 days' time. And you know you are the bona fide owner of that property. What will you do to stop that? You can't just go and start challenging the authorities, the people that put it. All you do is to run to court. So then that please, because by the time you say let you file your process or whatever to sue them, maybe you're coming home, you might see your house
Demolished. Okay.
So you go to court, run to court with your facts, because you have to attach an affidavit. That's where the details of your reason for the ex parte order has to be given. Say, my Lord, please help me. If you don't give this order, the tendency of me suffering an irretrievable loss or damage is very possible. On that note, such order will be given.
And that is interlocutory order. That's you just
an interim injunction, yes.
Interim injunction.
Yes. So when you file that one, you also file a motion on notice. Motion on notice is to put the other party on notice so that based on the order before them, don't demolish. They have to come and show the court the cause why
they have to
do that. But before then, you have to stop them first, because that 2 days.
That's why it called interlocutory.
Yes.
Interim.
Yes.
Okay.
So if such thing is not done and your house is already down,
Okay.
you can't be asking the court to ask them to come and rebuild. No.
Okay. So when there's an urgency.
Yes, extreme urgency. That's when the ex parte.
There's another word now, ex parte. What do you mean? Because we are not all lawyers. What do you mean by ex parte?
Ex parte
yes.
application is when the other party is on the no.
Okay.
You don't need his consent. You don't need him to be aware.
This scenario here, you are suing me now, and there is need to get an urgent interlocutory injunction, as I've explained. So there is possibility of not putting me on notice.
Exactly. In this particular one,
yes.
in ex parte, you don't.
And whatever order that is given by the court will stand.
Yes. Based on the nature. That's why I said when you file it, you also file on notice along. When the court now grants that order of
ex parte,
you now go and serve the one on notice. You serve them along. That this is the order of court. Come
and show cause.
Yes, why this is like. In some cases, some it depends on the nature of cases. Some cases you don't even need to file the notice, the motion on notice along. For instance, in EFCC matters, if there is fraud reported against someone, and there is need for them to investigate it, and if they need to write to the bank to put a place no debit
on the account, they just get that ex parte order.
Because they don't need to notify that party in that instance, because you notifying the party
will cover his track.
Exactly. So in that circumstance, you don't need to put the person on notice even before or after.
Okay. It's just to get that ex parte order.
Yes, to make sure that things, the status quo of the evidence you need to investigate are not tampered with.
Okay, thank you very much. Well said. Now, are there some processes which a court order may be granted? What are the processes? Explain the processes.
Okay, the processes
exactly.
is...
Because you don't just go and get court order. There must be processes. Exactly.
You file a motion.
Okay. What is the motion? What is the content? So that because we're educating our viewers here on things, points of law. Yes. In the motion, you go by motion because, just like we said, it's an interlocutory. It's an order you're seeking for. It's not a full suit that you want the judgment at the end of the court. So you go by motion. Anything before judgment comes by motion. So you now go by motion.
which we've explained the expertise extensively and on notice. In this motion, you state your reason and the authority, for instance, the section of the law that permits you to approach the court on that manner, on that procedure. Now, you now detail the reasons, the grounds for the application in your affidavit.
Okay. Okay, apart from that, you have to get an affidavit.
Yes, on oath, so that the court will know you're serious. Because you know, when you lie on oath,
it's a criminal matter.
Beautiful. So you have to detail all and state the reason, the damage you presume you are foreseen to suffer. You still tell the court that in your affidavit. After which you now back it up with your brief of a written address.
Okay. Oh, so generally there must be three things. First of all,
yes,
the motion,
the affidavit, and the written address.
So these are the things, the processes.
Yes, you
once you establish
it
before the court,
yes,
that order may be granted.
Exactly.
We have seen many issues by which conflicting orders have been going around, especially that of coordinate jurisdiction. When we come back from break, Barrister Eudora is going to explain to us the reasons and what might happen that will lead to many conflicting orders of coordinate jurisdiction. Please do join us again. Hi, you are welcome to the Speaker on ACNN Television, reaching you from Abuja. The Speaker is a platform by which we treat some topical issues happening in the polity. On today's episode or segment, we are going to be looking at the statement that says, hopeful Nigeria or hopeless Nigeria. My name is Anozie Chinomso. The word hope is used to anticipate and wait for something good. In other words, hopeful is an expectation of positive promise with an inclination that something palatable and better is about to come. This means that in a hopeful nation, the level of zeal towards manpower and development is very encouraging and appreciated. All these hopeful thoughts and reasoning towards the word hopeful can never be the same with hopelessness. This is because the word hopeless comes with negativity, backwardness, discouragement, disappointment, and unwarranted decay in the land. With the kind of inconceivable and unthinkable things happening in Nigeria, I'm moved to ask on whether we are living in a hopeful Nigeria or a hopeless Nigeria. I was shocked to my marrows when I heard from Major Bashir Jigar that the security architecture of the Nigerian Defense Academy was compromised by unknown gunmen who gained access into the residential area within the academy, killed 2 personnel and abducted 1. What a hopeless Nigeria. It is only in a hopeless Nigeria of these days where such sordid and morbid story makes a headline on the front pages of newspapers. Nigerian Defense Academy, where we train our security personnel, compromised? Lord have mercy. When a friend of mine constantly tells me that there is no need speaking for positive change in Nigeria, and further urge me to rather keep quiet and hold my peace, is a clearer indication that we are living in a hopeless Nigeria. Because it is only a hopeless person in a hopeless Nigeria that can make such a hopeless remark. In a situation where some political elites are asking for an amnesty for bandits, Boko Haram and kidnappers, is a clearer pointer to the fact that we are living in a hopeless Nigeria. When former captain in Nigeria Army, who is now an Islamic cleric, who goes by the name Ahmed Abubakar Gumi, eloquently and consistently speak in favor of the bandits, and further instigates the government to grant amnesty to these wicked men of underworld, and nobody has called for his arrest or detention at the Department of State Services DSS, but Mazi Nnamdi Kanu's fundamental human rights has been constantly violated on a daily basis for doing absolutely nothing, is a clearer picture to the fact that we are living in a hopeless Nigeria, where the expectations and aspirations of an ordinary Nigerian to have a better country where peace and justice may reign is not being met is also another indication that we are living in a hopeless Nigeria, where the commercialization of bandits and kidnappers has become another source of social and governmental contracts, where some massive ransoms of millions of naira is paid to these terrorists, is another evidence that we are dwelling in a hopeless Nigeria. In a situation where the singing of rhymes that youths are the leaders of tomorrow, and these wicked old politicians constantly do everything possible to ensure that this tomorrow never comes, is also an indication that we are living in a hopeless Nigeria. When the toll of death of innocent and hopeless Nigerians keeps rising on a daily basis, and yet government is not doing anything about it, illustrates how hopeless Nigeria can be. How hopeless can Nigeria be? That taking care of bandits and welfare of cows has been the political agenda of a government for the past 6 years. How hopeless can Nigeria be? That those who eloquently castigate previous administrations are doing worse than their predecessors in office. How hopeless can Nigeria be? That the sweet and peaceful country once enjoyed is gradually disintegrating and collapsing in our very eyes. How hopeless can Nigeria be? That we tend to defend these political thieves when they are doing wrong, especially when we are benefiting from them, either directly or constructively. How hopeless can Nigeria be? That tribalism and ethnic extraction have domiciled in our very beings and veins. How hopeless can Nigeria be? That we see virtues in ourselves and see vices in others. How hopeless can Nigeria be? That we are co-authors of our own misfortune. In order to justify Nigeria, I therefore speak. Until our leaders stop prioritizing the welfare of cows in this country and cease to make laws that will benefit animals, have a clarity of thought in canvassing the positive ways to bring unity and well-being of citizens, and transfer the unequivocal love government has on cows to human beings in this country, in order to restore a long-lasting peace, joy, happiness, harmony, and hope we have already lost, we shall continue to live in a hopeless Nigeria instead of a hopeful Nigeria. My name is Anoze Chinomso, and I just want to speak. Hello, glad to know that you are still there with us. We are still here with Barrister Eudora Ezonye. Counsel, before we went on break, where you have made us to understand what court order is all about and the processes that you have to take in getting that order. Nobody just walk into the court and expecting court order. Now, based on your explanation earlier, before we went for break, you discover what has been flying in the news, especially in the political sector, by which you get a conflicting order from one coordinate court of the same jurisdiction and all that. Now you look at the issue of secondus. Some of the party members that are grieved, some of them went to court and got an order that he should stop parading himself. He also went back to court of jurisdiction that is still the same. And you begin to see, even in Anambra State, that of the ABGA, Soludo, governorship candidate. What's your take in all of this?
Well, it's really unfortunate, because that ought not to be. Because the Constitution in section 240 made it clear that it's only an appellate court that can set aside an order of court by the High Court. Now, if the judges were circumspect and had directed the applicants to put the other party on notice, that would have given them the opportunity to know that there is already an existing order. But because they allowed what we call in law forum shopping, someone trying to make sure his or her case gets to a particular judge, because I believe if that was not allowed, this wouldn't have happened. Because just like we discussed earlier, we have circumstances whereby this kind of orders can be made. And it was obviously laid to rest in Kotoye and CBN.
Okay.
Reported in 1985.
That's a judicial pronouncement?
Yes. Where the Supreme Court said that it must be before you make an order by motion ex parte. It must be an extreme, a matter of extreme urgency. And just like you said, in this one, there is no urgency. There is no urgency. There is nothing to lose. Okay, that I'm no more the chairman, or stop parading yourself as the chairman. Ordinarily, the judge himself couldn't even have said stop parading yourself as the chairman, because that is like a judgment. Just
like you explained earlier, it's different from the order, because
yes.
Judgment is a final thing, but
yes.
Order is something that is somehow interior.
Yes, he could have asked them, okay, maintain status quo, pending when you file the proper suit to argue your matter, to know if really maybe his tenure is over as the chairman of the party, or if he has run foul of one of the conditions that will make him to cease to exist as the chairman. So here we see it gave room for judicial recklessness and abuse of court process.
Counsel, are you saying that the courts of coordinate jurisdiction cannot override themselves?
No.
Okay.
No, you know, in the only case where it can be done is in the face of a matter that is patently a nullity, whereby, for instance, I appear before you as a judge and said I want my marriage with Mr. Stephen or A dissolved.
Okay.
And I presented a fake certificate of marriage before you.
Okay.
And you ruled on that. Only for you to discover that what was placed before the court was not existing. The marriage never took place. You understand?
So the marriage was void, ab initio. That's already
nothing. As in, it doesn't occur. So in that case, you can see that in law, we say that the judge was misled. When you mislead a judge in such circumstance, the judge can recall.
Okay.
You understand?
Back the matter.
Yes, when the judge is misled. Because when we say something is a nullity in law, means it ought not to have been in existence.
In the first place.
Yes. But not when there is a matter and your fellow brother judge has given an order and you now want to sit on it. No, it's not allowed.
Do you perceive any political willpower there? Or your own opinion?
Well, just like I said, it's called forum shopping. And yes, you can say there's a political will in the sense that in this scenario now, the urgency was being manufactured by the politicians.
Definitely.
They made the judge believe.
Definitely.
And it's unfortunate too that the lawyers on the bar, because judges didn't do this alone.
Yes. Yes.
Lawyers, it takes two to tango.
Exactly. It was lawyers that approached them.
It was lawyers that approached the court, knowing that this is exists, because just that the judges, just that they didn't go further in making sure that the right thing is being done. Because when you look at the matter, it's bereft of extreme urgency. So they would have said, put this person on notice. By the time you put the other party on notice, that would have come and say, ah, my lord, there is already an existing order on this the same matter. That this application before you is an abuse of court process. Please don't honor it. And that would have put an end to it. But because they didn't do that, these lawyers took advantage of that.
Now, this orders counsel now, as a lawyer, as a guru lawyer in law, what is the take, or what in this conflicting orders and all that? What is the take? For example, which order are they to believe now? Are they to, you have got, for example, the issue of secondus. Some say he's no more the chairman. He went back to the court again. That's what declared that he's a chairman. So in this circumstance, what happened? Is he, who we believe, which one is more superior? Because they are still the same court of coordinate jurisdiction.
In this circumstance,
yes,
and the one that will be superior is any order gotten from the appellate court. For instance, you can see what's happened in the one of in the case of Valentine Ozigbo in PDP.
PDP, exactly.
Appeal court declared him the rightful candidate.
So whatever the High Court they are doing,
that put an end to it, because the appeal courts are the ones with the jurisdiction, the appellate jurisdiction over that matter, not the court of
and they have the power to also override whatever
exactly
thing.
Because also in the case of Okoye versus Nigerian Construction and Furniture Co. Limited, reported in 1991, Nemeka Aguje of blessed memory put it that, except, just like I told you, only in but special cases, it has to be so, because the right to set aside, I'm quoting him,
yes,
to set aside orders of court is ordinarily the prerogative of an appellate court, which itself operates on the well-tested reasoning that two heads or sometimes more are better than one. That's why it's in appeal court or Supreme Court, they don't sit alone. They sit in panel.
Because I know Court of Appeal might be 3, then maybe a Supreme Court 5 or 7 as the case may be. But the High Court is only 1.
Exactly.
That's the point that Honorable Justice of blessed memory is trying to illustrate.
Because in section 240 of the Constitution, it was stated clearly that it's only the appeal court. It's an appellate court that can override
whatever the High Court must have decided.
Okay. Because once, even in judgment, for instance, if a judge of High Court gives judgment, he becomes functional official.
Whatever he has discharged his work.
At that point, his power has stopped. His power over that matter ceases to exist, because he has given his judgment. So in this case, that's why we're found at it. All those their forum shopping orders, the one of the appellate court, any of them that goes further
and gets another
through the right procedure by approaching the appeal court, whatever order that is given there
superior
takes precedence over all the one given by the.
Thank you very much. We are going to have some minutes just to end this program, before just less than 2 minutes. Now, we heard the trouble CJN. I call him trouble CJN. In fact, some people have applauded him that that's the right step in the right direction, while some people are saying that, what is coming out of it? Now, the question is, before we go, just 2 minutes, that summoning of those 6 judges by the Chief Justice of Federation, is it a right step in the right direction to curtail all this?
Perfectly.
Why do you say so?
Yes, because the judges in question are not answerable to him. The judges in question are answerable to the chief judge of their respective states, and the chief judge are answerable to the CJN. That's why he summoned the CJN.
The judges, the chief judges
of the states that are affected.
Okay.
And as you can see, he on his own capacity cannot discipline them, because the judges are also subject to NJC. So now, after his summon, by reading the Riot Act, we heard, although their names have not been disclosed, that 3 judges that were involved had been issued a query to show cause why they will not face disciplinary action. And NBA on their part, the president of the Abata, has also commissioned 3-man committee headed by Ajibade SAN to look into lawyers, just like I told you earlier on. It takes 2 to tango.
Okay, the lawyers that approach the court.
Yes, in this frivolous way. Because this is not what we are taught in law school, and this is not how practice ought to be. So he has also commissioned them so that they will look into this forum shopping that some lawyers have embarked on that led to this. So that if they come up with their own recommendation based on their investigation, those involved too, because in the bar, under the Nigerian Bar Association, we also have disciplinary committee that check the excesses of lawyers in course of their practice.
Okay, so it's a right step in the right direction.
A very bold, perfect step in the right direction.
The Chief Justice of Nigeria did well by summoning the 6 judges that are affected in all this, as we can hear from our guest barrister, Ezide Udor. I want to appreciate you for coming, and we pray when next we call you out of your busy schedule, you will still oblige us to come. Thank you very much for coming. We appreciate you.
You're welcome, sir.
A court's order is a respected and revered instructions or directives emanating from a court of competent jurisdiction, as must be seen and treated as one. Once a court order is issued, it must be complied with to the letter. But this recurring trend of absolutely ridiculous conflicts in rulings and judgments of courts of coordinate jurisdiction tarnishes the image of the judiciary. I think that the strongest possible measures and sanctions must be applied to any judicial officer who violates the code of judicial conduct. This is because I have difficulty in understanding how a judge sitting in Jigawa State will presume to have jurisdiction in respect of election matters arising from Anambra State politics. This is clearly prima facie evidence of gross judicial misconduct that is full of judicial lawlessness and rascality. The National Judicial Commission (NJC) must take urgent steps to stop this malpractice in order to restore the honor, dignity, and glory of judiciary. Viewers, this is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, this is Anozie Chinomso wishing you the very best, and bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.